Why are you seeking to write a will? Who do you want to care for when you're gone? How are you going to do it? Why does it matter to you? All of these questions have an answer, and behind all of the answers is an intention. You are specifically looking to answer these questions for a very definite purpose, and your estate plan is just a written expression of that intentional purpose that you first have to have in your mind. So, when we talk about the field of law, we don't talk about this often, but is literally the first thing we have to look at, is the mind. Okay, mind matters more than we really give it attention to, but that doesn't mean that it's not important. It's actually probably the most important thing again. So, for instance, a lot of people watch like Law and Order, right? And whether it's what Criminal Minds or SVU, all this stuff. I'm not a big actually fan of that stuff, even though I will say my favorite legal TV show was Matlock. And that's not what influenced me to be a lawyer, but I remember watching it very fondly with my father and the theme song and just how cool he was, right? So my point is like a lot of people are very used to what goes on in the courtroom from that kind of entertainment perspective, right? So these things are more known, especially in the context of criminal law, right? Where somebody is done something wrong, something happens, somebody's accused, and then you have the prosecutors and everything trying to find out who done it, essentially, right? Or accusing them, and they go to court. And there's a big trial and all this drama, right? Which is not usually like that, but it looks good like that on TV, okay, right? So, for instance, if you take those kind of TV shows in the field of criminal law, we'll say there are many crimes known as specific intent crimes. And this means that you must have the intent, you must have the actual thought in your mind to commit the crime before you do it. So the intention actually comes before the action. You think to do the thing and then you do it. And in the area of law, this is called mens rea. All right. So your thought. And then the actual crime itself is the actus reus. Okay. But you have to think about it first. And we see this again all the time in murder cases. All right. We have the varying degrees of murder in the first, the second, the third. And murder in the first is the highest because that has the most thought of what you're going to do. Right. You're lying in wait. You're waiting for the person to come outside so you can ambush them to do the act. Right. Or if you're poisoning them, you're specifically doing something to cause the action you want to see, which is right, their death. So we see this, that's the mind's intent, the mind's thought to do these things. Um, and it's so important in this context. The mind's intention is so important that you cannot be convicted of murder without intending to do the action of killing. Okay, and this is where we have the lesser charges of manslaughter. So yeah, the act is there, somebody died, but did you mean to do it? Were you trying to do it? Or were you so reckless, in it, which is what second degree murder is, where of course it would happen, right? If you shoot into a crowd, of course that has to be the natural action of your thought, right? Of what you're doing. But if you're not intending to do that, it's not murder, even though somebody dies. Okay. And so that's just how powerful thought, that's how powerful the mind is when it comes to the field of law, just in the criminal context, right? And we see this all the time in these courtroom TV shows and all the law and orders and everything like that. But when it comes to estate planning, right, which is also just another field of law, the mind matters just as much. And sometimes you can argue maybe even more, for the following three reasons that we will discuss. First of all, capacity. In addition to estate planning, literally just being the written intentions of your mind, right? Your last will, what you wanting to happen after you pass away. If you do not have what's called a sound mind, which means the legal capacity to do what you are doing, your entire plan can be invalidated. The entire plan will be no good. So in the field of estate planning, and I practice in Michigan, but I am almost certain that there is some kind of, or some variation of this very basic necessity in all 50 states, okay? It is a legal requirement that the individual, right, who's going to create this plan, whether it be a will, a trust, powers of attorney, anything in this field, be at least 18 years old, right? You have to be an adult. And the age of adulthood in the country is 18 for this purpose. So you have to be at least 18 years old and you have to be of a sound mind. And it has a very specific legal meaning. But I'm going to break it down here just for more simple understanding. And so essentially, a sound mind, you have to know what you're doing. And often this would mean that you understand what you have in your possession. It's called the bounty, right? What is available to you? What is in your possession? Your home, your cars, your bank, whatever it is, all these things, you have to know that these are your things that you have possession of. And then also what we call like a natural heir in life. And that just means the people in your life that would naturally take over or take possession of those things, so, should something happen to you, all right, such as your spouse, your children. It just makes sense that, if you were to pass away and you're married, your spouse would take over whatever it is, right? That makes sense from a logical standpoint, and it's kind of where the legal requirement follows as well. Okay, so you have to know these things. If you don't know these things, if an individual does not understand these basic requirements, then they are likely not of a sound mind, which then means that they likely do not have sufficient enough mental capacity to create their estate plan. Okay. In fact, any good attorney, okay, which many of us are, right? But not everybody. Any good attorney, though, will never put a plan in place of someone who does not have capacity, because not only logically, but again, legally, they're not able to. Now, this can be hard for us to distinguish, especially with older individuals that we often come into contact with who may or may, they may be swinging in and out of it because of the things such as the dementia, Alzheimer's. Those start to set in at different ages, advanced ages. So, we're not experts in that, right? We're not doctors, but just asking a lot of questions and just kind of getting a feel for it, you can tell who has it, who doesn't have it. And if there's ever any gray area, it's best not to do it, right? Just for liability purposes, because it's illegal, right? You're not legally able to do that without the capacity. However, okay, and this is just not for attorneys, but anybody. However, just because it's illegal doesn't mean it can't be done, right? Doesn't mean people won't try to do it anyway. I'm not advocating for you to do anything illegal, but obviously people do illegal things all the time, right? That's why they hire an attorney to maybe get them out of something if they know they've done something. Or, if they see something come up that may be illegal, hire an attorney to go after that person, right? Or that entity, whatever it is. So these acts are done all the time. It's just a fact of life. But when it comes to this illegality of capacity, this is where we do have some common challenges come up. So, someone who's elderly, um, again, especially this often comes into practice with dementia, Alzheimer's, things of that nature. They may have a caretaker or maybe a family member um, who's kind of waiting in the wing, right? And may try to use that to their advantage. Okay, so there are common challenges that we can use to capacity that come up, such as fraud, undue influence, and duress. So fraud means, someone else kind of using that individual deceptively. Um, Undue influence is kind of false control. They're exerting too much influence over them, and they're really doing their will, not the person's will. And then duress, pressure, right? If you don't do this, then this will happen. Pressure, still just kind of taking advantage of a weakened individual to plan what may not actually be good for them. Again, essentially taking advantage of the weak. And this happens often in the case of elderly individuals who are maybe suffering from those kinds of things, such as even early, Alzheimer's, dementia, things of that nature. So that's why the mind is so important. Number one, in estate plan, because capacity, you have to have that. If you do not have it, the plan is basically no good. All right. So the second one is conflict. All right. In addition to your mind's intentions mattering when putting a plan together, conflicts are certain, especially after death. Okay. Conflicts are certain in life. There are always going to be people we're in conflict with, or people that are just not in agreement with what we're doing, whether they really have any say so or not. They'll let us know. All right. We see this on social media all the time. Like, I'm on Instagram and somebody can post, their engagement picture, and somebody else will say, why is it on the beach? What are you trying to say? Who are you trying to, people just be in conflict. They just want to be fighting. I don't know what that is, but it happens, right? All the time. And when it comes to death, I've seen in my practice, that's the time for some people to just seize on the moment. They've been holding it in for so long, and now that this person, it might be a cornerstone of the family, now that they're out of the way, it's time for me to take over, right? So again, often the deceased is the one who held it all together. And now that they're gone, these forces have been waiting and they're seizing advantage. They're going to exert their control, their lust for dominance, especially over like a family home. Even if they don't live in the home, you guys, I'm telling you, the last couple of years, I can't count how many cases I've seen where, last surviving parent passes away, whether it was mother or father. And these are adult children, adult siblings, often four or more of them, who do not agree about what to do with the family home. Usually, most of them do, but there's always the one. I don't know what it is. There's always the one who doesn't even live in the home, has never taken care of the home. Everybody else has been upkeeping and caretaking, before mom or dad passed away. But there's always the one that, as soon as that person passes away, they're in control. They get to decide what to do with the house. That individual, right? And they don't care about what siblings think, even though siblings all have an equal say in the matter. This happens so much after death. Okay, when that kind of happens. However, what I try to encourage and what I do and what I'm saying to you now is having a well-written, often professional, estate plan can help to hinder these conflicts because, once again, your mind's intentions, the power of your mind, the mind's intentions are expressly stated in time, energy, effort, and even wording that you use in a well-crafted plan. All right, so I give this example. I had a conversation within the last week or so with my 10-year-old daughter about wills. Funny enough, I just asked her, like, do you know what a will is? Do you know what this is? Like, because she knows I'm a lawyer, but I'm like, does she know what I actually do? Does she know what that means? And she knew. She knew about last will and testament. I guess she saw a video in class one day. I was like, okay. So I'm not like speaking a foreign language. You get it, right? So I told her, I was like, yeah, I help people write their wills. I help them to say who they want to get what after their death. And I told her that actually anyone, and this is true for you, but don't do it for these reasons I'm going to say, okay? So anyone can actually write their own will. They can do it anywhere they want to. And we were at a restaurant. So I said, you can take the back of a napkin and write your will on that napkin. I, Tina Patterson, give everything I own to my daughter and sign it, date it, whatever you want to do it. You don't have to sign it, date it. Just write it down. And that can be your will, right? But I also told her, though, that as lawyers, once again, we help someone write the will. And I told her, yeah, that can be your napkin will, right? But what I would do for my clients is we have at least a 10-page long document. It's clearly written. It is labeled. It's paragraphed. There are numbers that match up with the pages. I tell her that, all the names are in there, property is in there, who gets what, when, how they get it, what is controlling, what's not. And then we actually have it signed by the person. We have it signed by the witnesses as required by law, right, to be valid. And I even have it notarized often, by a notary who's going to come and say, yes, this was done in my presence. I checked my stamp of approval, right? And it's this beautiful, long crafted document that says the exact same thing, but expressly how, who, what, where, all that thing, right? And so then I asked her, I said, which one do you think would hold up better? Which one do you think holds more force? Which one would be considered the real thing? The napkin or the 10-page document with everything in it, right? Now, mind you, she's 10 years old. Kids are smart. They are some of the smartest beings on the planet. We must listen to them. Even if we think we know better, it helps to listen to them because we can actually learn something from them we don't know. But in this case, I don't even think you have to be a child to understand this, right? She said the 10-page will. The 10-page will, not the napkin, okay? This means that having a well-crafted plan with well-documented intentions can help to minimize the conflicts that often arise after death. It is harder to make a case against a well-crafted plan than it is against a little flimsy napkin. Why? Because it took more thought, first of all, more thought, more mind power to clearly write out these ideas, clearly write out these intentions, right? Not just real quick on a napkin and that's it. You can do that with anything. But that you exercise the mental creativity, mental faculty to express those same paragraph wishes in 10 pages of paper, right? You took the time to do that. You took the effort to do that. You paid an attorney to do that. So there's a money cost in there too. There's an investment in it, right? Um, so that has more value, that has more weight on it than just a little piece of paper on it, a little napkin. Okay. You didn't just have the idea and jotted it down. You put the idea into very thoughtful action through this will. Okay. And that's just the will. There are other documents too, but we're talking about just the will. Now, with this being said, will people or can people still try to challenge this, well crafted, well documented will? Of course. Of course. Nothing is foolproof. I want to say that for anybody listening, because I know even as attorneys, even as lawyers, we want to be exact on the money, and nothing is foolproof. There's always going to be a challenge, and people are often going to be the source of the challenge. Okay, that's just life. But does that mean just don't even do it or it's not worth the time? No, no. Okay, barring the issues we just discussed, such as the undue influence, the fraud, the duress, right? The kind of mental manipulation, as long as a person has capacity, the conflict from whoever is trying to take over is likely to be resolved in favor of the will for the things we just mentioned, because there's time, because there's intention, because there's effort, because there's investment, right? With money to pay a lawyer to do it. These things matter more than somebody trying to say, oh, it doesn't. Okay, that just kind of makes common sense in that way. So don't be discouraged thinking that, oh, well, you know, because it's not conflict proof, it's no good. That's not true. There is no such thing as conflict proof. Somebody will always try to challenge you. Somebody's always trying to go after what's yours. If it's worth it to you, fight for it. And I have a series of videos on that. What I think it's called, what will you fight for? It's about 3 parts on this channel. And you can really understand then why the fight has to be worth it if you're going to go after it. Okay. Just a fact of life. All right. And then finally, the last reason why mind matters in estate planning is kind of twofold. I didn't know if I should do a 3 and a 4, but I'm just kind of putting it together. Control and care. All right. Once capacity is determined, right? So we know we have the mental ability to do this, and we use it to minimize or reduce the potential for conflicts that we just talked about by putting our intentions in writing through a plan. And there's the issue of control. Who will get what, when, where, why, and how? Okay. I don't know if you remember, I was, a writing and history and all this stuff kind of nerd when I was in elementary school. So I liked doing interview kind of things and questions and all that stuff. So the 5 W's, right? Or if you're doing a book report, the 5 W's of who, what, where, when, why. And then there's the last question, not a W, ends with a W. How, right? But the point is that these are questions, and questions have to be thought through. They have to produce answers, right? But do you see how just in these 5 simple questions, there's a lot of thought. There is a lot of thought. There is a lot of thought to produce that answer on the other side. And this is the power of the mind of in estate planning and action. Okay, so control. How are we going to exercise our control with these questions? And then the whole point of really estate planning too is to have that say so, that control over your things for who after you're passing away, right? And then the second part of that is the care, which is really the main reason for even doing any of this. Why does it matter? Who cares? We care. Why? So we can control what happens to our things, to care for the people that we love the most. All right. So we can ensure the house will get passed down to the kids. So we can make sure the money will go towards their tuition. We can make sure that they get the lessons that we want them to learn and to use to succeed in life. And it doesn't have to be natural children. It can be, if you do it correctly and well, people that are not your natural children, but you looked after like that. When it comes to business, it just applies to the company, right? It's always about furthering your vision, furthering your intention, the things you see in your mind by putting the plan into action because you care. This is something you care about. It's your life's work. It's your progeny, right? Your children. It's something that is bigger than just you. So you know that when you pass away, it's going to still have a purpose. That's the entire matter. That's the entire matter of it all. but it all starts with the thought. This is why mind matters in estate planning, and obviously mind matters overall in life in general. Okay, so that's our video for today. We hope you've enjoyed. We hope it's been helpful. And if it has been, please do like, share, and subscribe for more. We will return next week at this time, which is our new time. We used to be on Wednesdays, but now we're on our new time, which is Thursdays at 1:30 p.m. Eastern Standard Time. So this is Attorney Patterson. I will see you for a special leap year edition, actually, next Thursday, February 29th, 2024 at 1:30 p.m. Eastern Standard Time. All right, take care.